Thanks, everybody, and welcome to the final session of the 2025 Animal Law Symposium. My name is Chris Green. I'm the Executive Director of the Animal Legal Defense Fund. I have a few housekeeping comments items before we get started. First, all sessions do feature closed caption subtitles. So to enable this feature, just click the upward arrow near the CC button at the bottom of your screen and select Show Subtitles. Also, please enter any questions you have into the Q&A box that you'll see at the bottom of your screen. We'll get to as many of those questions as we can. And the symposium is being recorded, and the recordings will be shared with you later via email. So you should be seeing a poll. There it is, right over my notes. Please take a moment to answer the poll question on your screen. If you are seeking continuing legal education credits for this session, please click yes. Attorneys seeking credit will receive information via email after the symposium concludes. I'm clicking yes. Oh, I can't vote. Okay, great. Thank you. Now on to the panel. This panel is entitled Looking Ahead, Legal Challenges Facing Animals and the Environment. It will examine new regulatory changes that impact the environment and animals, recent litigation at the intersection of climate and animal agriculture, and legal efforts to strengthen environmental regulations for the animal agriculture industry. Our panelists are Dana Bray, who's a clinical lecturer in law and a legal director of the Law, Environment, and Animals program at Yale Law School, where she leads the Climate Change and Animal Agriculture Litigation Initiative. She also serves on the board of the directors for the Animal Legal Defense Fund, and previously has been the general counsel for both Mercy for Animals and the International Fund for Animal Welfare. Emily Miller is a staff attorney at Food and Water Watch, where she engages in strategic litigation and advocacy to combat the polluting and exploitative impact of industrial animal agriculture. Since joining Food and Water Watch in 2021, Emily primarily focuses on legal strategies to address factory farm air and water pollution, harming frontline communities, the environment, and the climate. Eric Glitzenstein, lastly but not least, is the Director of Litigation at the Center for Biological Diversity, where he oversees roughly 60 attorneys working on a host of legal issues related to animals and the environment. He's taught wildlife law at the Harvard Law School and co-founded the premier DC law firm focused on animals and the environment law and animal and environmental law, known as Meyer Glitzenstein, which he and his partner Kathy Meyer ran for 26 years. They both also were recipients of a Lifetime Achievement Award at the last Animal Law Conference. So with that, we'll just jump right into the questions. So Dana, let's start big picture. Your research focuses on climate change and animal agriculture. How do you see work in that area changing under the new administration?
Thanks, Chris. Honestly, we've heard a lot in this symposium so far, which has been great, about sort of a lot of changes and new things to adjust to. And in the area of climate and animal agriculture, in some ways, not too much has changed. And that's because the climate impacts of animal agriculture have not been well regulated by any federal administration. Those climate impacts are largely unregulated by the states as well, mostly unregulated in most countries around the world. For this reason, because there is not at present adequate regulation of the significant climate impacts of animal agriculture, we're talking about probably 15% or more of all greenhouse gases globally come from animal agriculture. We know that we're not going to be able to reach the targets of the Paris Agreement without radically reforming our food systems. And a big part of that problem is animal agriculture. So if you look at agricultural emissions in this country, in the United States, nearly 80% of agricultural emissions come from animal agriculture. So it's a big piece of the puzzle of responding to climate change. Unfortunately, this is an issue where we have to walk and chew gum at the same time. It's not just that we have to address fossil fuels. We also have to address other climate superpollutants like methane and nitrous oxide from animal agriculture. Because there really hasn't been sufficient policy activity in this area, we are starting to see, and this is a focus of my research at Yale, we are starting to see an emerging litigation trend of cases focused on seeking to address the climate harms of animal agriculture. And if anyone's interested in more details, along with one of our fantastic students, we published a paper in the Columbia Journal of Environmental Law last year about looking globally at this trend of emerging litigation around climate and animal ag and thinking about where we think things might go. But I think, all of us know that in this country, neither party has been particularly committed to or focused on addressing the externalized harms of industrial animal agriculture, and that's true for climate as well.
I would say great, but yeah, it's not actually great. But great answer. Uh, Eric, there have been a flurry of executive orders over these past first 100 days, many with some far-reaching implications. What do you think are the most significant ones for animals in the environment, and why do you think that?
Mhm. Yeah, so actually much has changed in a lot of other spheres. Actually been over 140 executive orders. If you're keeping track, it's almost hard to follow up on these on a daily basis. And many of them are actually directed in one way or another at wildlife and the environment more generally. And along with the executive orders, and actually as part of the creation, as the executive orders is what everybody has heard about, which is the Department of Government of Efficiency, or as I like to refer to it, the Department of Government Evisceration, Elon Musk's brainchild, however you want to call it. And so there's both the sort of setting the stage for long-term legal change, regulatory change, but there's also the immediate hollowing out of the agencies that are required to implement major laws protecting animals, wildlife, and the environment. People have probably read about the thousands of employees who have been basically just fired with no real rationale. Many of whom are charged with enforcing, statutes that have a huge bearing. And in terms of sort of regulatory changes, a couple of very early executive orders made sweeping changes, but actually more significantly set the stage for even more sweeping changes down the road by declaring emergencies. And this seems to be one of the hallmarks of what this administration is doing. They sort of declare everything to be an emergency, and they use that authority to then unleash other kinds of impacts across the stage. So they declared emergencies both in terms of the oil and gas industry, the need to expand greatly oil and gas production throughout the country, as well as offshore, as well as a timber and minerals emergency. So that basically opens the door massively to basically going in and increasing timber or removal from national forests, huge increase in mining on all public lands. And basically, and in addition to sort of declaring these emergencies, these executive orders instructed the agencies to use all kinds of fast track authorities to have various destructive activities occur as rapidly as possible. So, both in terms of the Endangered Species Act as an example, and the kind of process supposed to go on under the ESA before you approve any activity that might have an impact on a listed species, invoking emergency authority to fast track those kinds of reviews, National Environmental Policy Act, which we may be talking more about in this conversation, basically going through a NEPA process, which is almost non-existent. The NEPA has been one of the principal statutes that's been used to safeguard wildlife on federal lands, as well as other environmental protections. And we're already seeing this play out in real time. So just to give one example, the Army Corps of Engineers, which is the federal agency which has to approve wetlands destructions, wetlands impacts, has already identified 600 specific projects around the country under the rubric of emergency energy and mining activities, and are basically giving almost non-existent public comment opportunities, as well as invoking these like emergency mechanisms for approving projects very rapidly. So these are going to be pipelines, mining projects, timber removals across the board. So we're already seeing that playing out in real time, and there will be legal challenges responding to that. The other just quick things to mention that already happened and already having real world impact are shrinking national monuments that have been designated by prior administrations across public lands, which could have had huge impacts on opening things up to hunting and other kinds of harmful activities, as well as people may have read about this. The Pacific Islands Heritage National Marine Monument, which was a huge monument that has been created a number of years ago, and the Trump administration announced that they're opening that up to commercial fishery, which was one of the principal purposes why that was created, was actually to limit the amount of commercial activity and fisheries in particular. So that's already having a huge potential impact. And just quickly, just mention two other things. under the Endangered Species Act in particular. One is, once again, something which is declaring very broadly an emergency that will allow agencies across the board to invoke all kinds of abbreviated procedures for reviews that would otherwise have to take a reasonable amount of time and have reasonable input from scientists and others to allow projects to go forward that have kind of all kinds of detrimental impacts under, again, the sort of characterization of the need to have emergency responses for energy production and the like. And the other one I would mention is something called the God Squad, which if people have taken classes under the Endangered Species Act or wildlife law know, this is supposed to be something which is a last-ditch effort that allows a cabinet level committee to allow the extinction of a species. It's only been invoked 3 times in the entire history of the Endangered Species Act, but one of the first executive orders basically tried to create an entirely new sweeping authority for the God Squad to preemptively declare that species could go extinct based upon whatever emergency this cabinet level committee would decide exists or warrants that kind of action. We haven't seen that go into effect yet, but under the executive order, it's supposed to start meeting imminently. And who knows what kinds of mischief they could turn out to be up to. So anyway, that's probably enough to completely depress people, or at least give people the the sense as to what's going on. I would say on the good news front on this score, lawsuits are already being filed responding to many of these things. And as people may have seen, one of the sort of advantages we have with this administration is they basically rush in such an extreme and usually not particularly well thought out way that there are a lot of sort of pretty easy litigation targets to shoot at. And so there's already been lawsuits. Some of them have already been successful in hitting back on some of these things. And as they take more concrete action under the executive orders, I think there will be a lot more opportunities to push back in the federal court. So both the bad news, but sort of the good news in terms of the opening up the potential for a pretty meaningful response.
And I'd just like to add on to your answer, Eric. I think, in addition to everything you said, the erasure of environmental justice from EPA's mission, and the closure of the Environmental Justice and Civil Rights Office within that agency, I see that as having damaging kind of ripple effects on how animal agriculture is regulated. I think it's a well-known fact that the communities that have disproportionately shouldered the burden of factory farm pollution are low-income communities, communities of color, and rural isolated communities, kind of the frontline communities that have really embody environmental injustice, because they're not only dealing with the pollution and the quality of life issues from the industrial animal facilities that neighbor their properties, but also a lot of other polluting industries that kind of concentrate in those areas that don't have the political will or resources to really fight them off. And under the previous administration, at least they had a stated commitment to advancing environmental justice, which was a helpful frame and tool for holding them accountable when it comes to the regulations, or really the lack thereof, of animal ag pollution. So, erasing those words from EPA's website, closing those offices, firing those staff is really gonna, I think, just further bury and hide the problem under the surface.
And Erica, are there no requirements of evidence to justify these so-called emergency declarations?
Well, that's a really good question. I think there is, and we're already seeing pushback on that in other spheres. And you may have actually just seen, I don't want to get too far afield, but in some of these immigration cases where they've tried to invoke similar kinds of authorities that don't really seem to fit. So even a judge in Texas just yesterday issued a preliminary injunction saying, the statute that says that you have to declare an invasion of a foreign country in order to basically send people out of the country under certain circumstances. There was no evidence that there was such an invasion, and simply saying there is and using the magic words doesn't make it so. And I think you'll see a similar kind of analysis in cases that are brought, challenging that just because the president declares something to be an emergency doesn't factually make it an emergency. So I think we will have some opportunities to make those arguments. Unfortunately, in a lot of these statutes, that the president purports to be acting under, Congress delegated a huge amount of power to the president. And, this is, again, probably getting further afield than we may need to or can in this conversation. But one of the sort of things that may ultimately happen with all this, if Congress rethinking at some point, do we really, it may be one thing to give presidents this broad power when we have certain kinds of people we could assume may invoke those powers in a responsible way. But when we have a president who is willing to basically declare everything an emergency, is that really the kind of executive branch authority we want to allow? But to answer your question, I think there will be opportunities to go in, and some of these have very specific language, like in the Endangered Species Act context. It's clearly an emergency that deals with disasters. That's clearly what was intended when they wrote it into the statute and the regulations. If you have a disaster like a hurricane and you can't do a real world ESA consultation before you have to take action, that's one thing. But to preemptively say anything I want to do to extract minerals, or anything I want to do to destroy the national forest, or anything I want to do any of these other spheres, it's emergency because I say so. I think the courts are going to say, A, that doesn't seem to be what that was intended with these provisions, and B, there has to be more evidence, more facts than simply a president declaring, at their whim, it's an emergency. We can do anything we feel like doing. But I mean, all that's going to have to be playing out in the courts, and will.
Yeah, great. Well, so we've talked about sort of the executive power there. Emily, recent Supreme Court decisions and federal policy seem to be shifting towards less protection for our nation's waters. Can you walk us through some of these recent changes and how they affect clean water protection generally?
Sure. So yes, no doubt. In recent years, there has been a kind of an unprecedented attack on our bedrock environmental laws. Most recently by the Trump administration and some of these policies and orders that Eric just talked about, but also by the conservative Supreme Court. And, it's not only trying to chip away at those laws themselves, but also EPA's ability and authority under those laws to really hold polluters accountable. And some of those cases have, for instance, been the Sackett case, which came out in 2023, which drastically restricted the scope of the Clean Water Act and which of our nation's waters are protected under that federal water pollution control law, taking out roughly half of all wetlands from federal protection, doing away with protections for more ephemeral water bodies. The next year, 2024, we saw the Loper-Bright decision, which did away with this longstanding precedent of judicial deference to agency interpretations of the laws that they administer, which of course has much broader ramifications beyond environmental law or laws that relates to animals, but certainly has an impact on EPA and its ability to pursue aggressive or ambitious regulatory programs to tackle some of these really difficult climate problems, water problems that we're seeing from the animal agriculture industry in particular. And then most recently, in just this few months ago, there was the San Francisco v. EPA decision from the Supreme Court, which further chipped away at the Clean Water Act. And EPA's ability and state regulators' ability under that federal law to issue strong water quality-based protections in discharge permits. So to make sure that polluters can't be violating water quality standards and polluting waters to such an extent that they become unsafe for public recreation, for drinking water, for other public uses. So, we have seen this kind of it almost seems strategic on the Supreme Court's part, but really weakening the power of the executive and the laws themselves, knowing that our Congress right now is not going to be passing laws with more specific language that are really going to be moving forward environmental goals. And of course, that's going to have ramifications on clean water protection generally, but also, again, as it relates to animals and the environment.
Thank you for that. Dana, again, you folks spend a lot of your time focusing on climate. What do you think the administration's withdrawal from various international climate commitments and climate action, such as the Paris Accord, mean for animals?
Yeah, so we have seen, a lot of action by the new administration on climate. And even before this administration, the world is blowing past the goals of the Paris Agreement and really on track. For example, to blow past the goal of 1.5 degrees Celsius above pre-industrial levels, which is what the UN Intergovernmental Panel on Climate Change has said we really need to aim for to avoid the worst impacts of climate change. We've just had our first, full year globally where we were above 1.5 degrees Celsius. We haven't technically breached the Paris Agreement yet because that has to happen for a number of years in a row, but we even before this new administration in our country, we already were not on a good path globally. And in the context of this symposium and the work of Animal Legal Defense Fund, this is all going to be grim for animals. All categories of animals are vulnerable to the impacts of climate change. If you think about natural disasters, we've seen, horrible stories about farmed animals on the plains in extreme heat. Disasters kill laboratory animals through flooding. Companion animals suffer in disasters that are worsened by climate change. We also are going to see massive amounts of migration in this country as people have to move from areas that are, no longer safe or economically viable for them to live in, and all of that will impact animals of all sorts of animals that are kept by people. Of course, when you think about the impacts on wildlife of climate change, it's really devastating. And I think, as folks who care about animals, we all know of particular stories that have really reached us and we find to be heartbreaking. It could be on massive scales like the Australian bushfires, and the conditions that cause those bushfires. There's science now that can specifically tie specific weather events and say they were a certain percentage more likely because of climate change. We know that climate change is contributing to these disasters. Thinking about coral reef bleaching, that's something I learned about as a kid as a sort of awful thing that was only happening in some places, and we're seeing massive coral bleaching events as the temperatures of the oceans increase to unprecedented levels. Something I've been following. I've never seen a moose. I've spent a lot of time in New England. I'm going to go on a moose tour this summer. It's not guaranteed I will see a moose, but I hope to. But on local NPR stations, I've heard about how warmer temperatures mean that ticks live for longer, and the ticks are actually killing young moose from anemia. So it's just, the impacts on wildlife are really heartbreaking. And if anybody hasn't seen it and wants to read more about this or has the stomach to read more about this, in his 2017 paper published by the Georgetown Law Review, my colleague Jonathan Lovewarn did a speculative total estimate, and he admits that it's speculative. But in this paper, he in 2017 estimated that if we continue on business as usual, we could estimate with climate change that 147 billion individual birds and mammals would lose their lives. So 147 billion. And he estimated at the same time that if we could keep global temperatures to 2 degrees above pre-industrial levels, there's potential to perhaps save the lives of 100 billion birds and mammals. So all of this really matters for wildlife. And if you think about other causes of animal death and suffering that animal advocates care about and do a lot of amazing work on, this was in 2017. John wrote 100,000 animals were killed in African trophy hunts each year at that time. 100,000 compared to 147 billion, or 57 million mink and foxes were killed for fur worldwide that year. 57 million compared to 147 billion. And the only other animal issue that really compares in terms of the scale of lives lost is farmed animal suffering. Right now, more than 90 billion land animals globally per year are slaughtered for food, and that's a massive issue of interest to the animal advocacy movement. But the main point here is you can't compare causes of suffering. That's not what I'm trying to do. I'm not trying to reduce things to numbers. but just to say that animal advocates really need to see climate action as part of their mandate. And if, this is quite grim, it could be quite overwhelming to think about, but one of the things that makes me sort of feel motivated and able to engage is that every fraction of a degree matters for the well-being of life on this planet. And that, one of the reasons that matters is because of climate tipping points. So climate tipping points are where if you have a certain level of warming, large-scale systems, climate systems, change in a way that becomes irreversible. So think about melting permafrost that's releasing massive amounts of methane, or think about melting ice caps that are increasing sea level. Those are the kinds of tipping points that can be avoided, even by small decreases in the rate at which we're warming. So that keeps me motivated. And in the light of the direction that we are seeing from this new administration and all of this activity, contrary to efforts that had been made by prior administrations, it's even more important that advocates, working on animal issues, working on worker issues, working on environmental issues, that we all find places to take action, whether that's at the state level, at the local level, or at the individual level. And as we mentioned, I work on climate and animal ag, and many climate experts agree that at the individual level, which is not the only level, we need to do all these things, but at the individual level, one of the most powerful things that an individual can do to decrease their own climate impact is to consume less animal products. So thank you.
Yeah, thanks, Dana. And that point about the fractions of a degree, because I think just to some folks, 1.5 degrees doesn't sound like all that much, but yeah, those triggers and the permanent impacts are really important. I think it's also important to point out that, kind of as you said, humans, we typically think in terms of animals that are threatened or endangered. And those are, when we're thinking about climate, some people look to those animals first, but they're very likely already threatened or endangered for completely different reasons. And, you could have a virus, not even theoretically, that comes through and wipes out 3 billion people, and the human species wouldn't be endangered at all, but it would certainly be a significant impact. And I think the same is true with a lot of the wildlife issues you were talking about. There just could be these massive impacts, and it might not endanger those animals, but it still would have huge impacts on our global ecosystems.
Yeah, it's a great point. And I just wanted to add, I just recently saw Professor Natalie Jasowicz speak about her work about wild animal abundance. So she talks about this gap in law. We have the Endangered Species Act that's focused on endangered species and preventing extinction, which is so important. But we also need to have our eye on wild animal abundance. Even the most common wild animals are really decreasing in their numbers, and that is, profoundly impactful for our ecosystems and for our quality of life, and particularly for those of us who feel sort of drawn to protect animals because of their own intrinsic value. I really point out her work because we have to be working on multiple fronts, and it's not only endangered species that are in danger.
Yeah, just to put in an additional plug for that, especially the animal protection world, animal rights world. I think that world has been too ready to cede that work to the quote unquote environmental community. And I'm very happy this panel is called The Animals and the Environment. Because especially when you get outside some of the areas like the ESA, Marine Mammal Protection Act, some of the more specialized focused statutes, the whole notion of protecting wildlife as a whole is something that should really be a point of consensus for the environmental community and the animal rights and animal protection community, because the right to a home, the right to a place to live, and just to sort of add to all the great stuff that Dana was saying, when you look at climate change as a synergistic effect along with other impacts on wildlife, habitat loss and degradation, and that has a huge intersection with climate impacts, because the more you change the places where wildlife can live, a lot of the wildlife communities are going to have to move elsewhere. We're already seeing migratory patterns have to shift, north or south, depending upon the wildlife you're dealing with. So the more you degrade and destroy habitat, the less opportunity is for wildlife to shift to those kinds of places. Pesticides is a huge impact on wildlife. And it's something that people are trying to get a handle on. But when you look at all these things synergistically, there is, we're literally a war on wildlife going on, and it's not just the most imperiled species, but it really is a place where the environmental community and the animal community can and should, come together and see this as both a human quality of life issue, but also a fundamental animal rights issue in terms of just the basic right to exist, within a healthy environment for both humans and all the species that we share the planet with.
Yeah, and there's, increases in just disease proliferation. I mean, right here where I live in Champaign, Illinois, there's a really targeted outbreak of tularemia and like the massive squirrel die-offs and, people's pets getting sick from it too. And you just wonder if there's a nexus there. But following up on something you kind of touched on before, Eric, there have been some recent developments involving the National Environmental Policy Act, which has been an important law for protecting wildlife and the environment. What are those? If you can talk a little bit about what some of those developments are and where NEPA stands now.
Sure. And Emily actually already touched on this, so I'll just expand on that a bit. NEPA has really been one of the principal statutes, not for environmental protection generally only, but also for wildlife in particular. And unfortunately, we're seeing massive assaults on NEPA in a range of ways. And a lot of this actually started with a DC Circuit case that people may have heard about called Marin Audubon, in which one of the judges on the DC Circuit had been opining for many years, and finally, in a case where the issue wasn't even brought up, decided that the agency which has issued regulations for many years, and pretty good regulations implementing NEPA, that the agency didn't really even have that authority, the Council on Environmental Quality. And then following up on that and picking up on that ruling, the Trump administration came in and basically literally withdrew every single CEQ regulation, just eliminated all of the regulations that for 40 years or more have been used to implement the statute and have been used to pick up on some of the stuff that Emily was talking about, environmental justice being brought into the analysis, wildlife impacts, cumulative effects, which is a huge issue when we're dealing with climate change and some of the other impacts we're talking about, just got rid of them entirely. And instead basically told all the agencies, now it's up to you to issue your own implementing regulations. And we're going to give you some guidance about how to do that. And the guidance, not surprisingly, is really awful. Not only does it eliminate environmental justice as any kind of a consideration, it basically eliminates cumulative effects. And so many of the things we're talking about, really, if you don't look at cumulative impacts and you just look at things in isolation, you're not going to have any kind of serious look at impacts on wildlife populations and animals and other environmental considerations. So that's sort of like the CEQ regulatory world, as well as what I had mentioned before in terms of fast tracking NEPA when it does reviews when they do happen. But the other thing is that CEQ is telling agencies, you don't even have to consider any public input. They're literally putting out guidance. It used to be under the regulations, it was extensive public involvement. Scientists could weigh in, experts could weigh in. CEQ is telling agencies, you don't have to actually let the public even have any comment on environmental impact statements, period. And so without any kind of, for those who have no administrative law, if you can't build a record and just leave it totally up to the agency, then, at the end of the day, you're not going to have much of an environmental review or, wildlife analysis or anything else. The other thing I would mention is a case that the center, the organization I work for, has been directly involved in, which is pending in the Supreme Court, to sort of pick up again on what Emily was talking about, how we have a court which is not friendly to the environment. We are waiting for a ruling in a case called Seven Counties, which involves a large project which was building a train in Utah that was basically designed to ship oil from oil fields in Utah to the East Coast, where it would have significant impacts on environmental justice communities in the Gulf, as well as all kinds of huge wildlife-related impacts where they're going to extract the oil from. And the center, along with others, won a case in the DC Circuit, basically saying the NEPA review was inadequate because they didn't consider what it referred to either the upstream or downstream impacts. The Supreme Court took this case for no particularly good reason, as far as we could discern, and is poised to issue a ruling any day now. And the fear that we have, given the composition of this court and following up on Sackett and the other cases Emily made, referenced, is that we'll get a ruling from the Supreme Court on top of the other regulatory changes, which could significantly cut back on the scope of NEPA review under the statute itself. We don't know. The arguments on the other side were kind of all over the map. Even some relatively not environmentally friendly justices were kind of scratching their heads about the new test that those people on the other side who are promoting the project are asking the court to adopt. So it's hard to be optimistic about a ruling, but we don't know how far-reaching the ruling is going to be. But that could actually happen any day now. So it could have come out next week, it could come out in the weeks afterward. But people can keep an eye on that. And then obviously we'll see how far the Supreme Court goes. So bottom line, unfortunately, is that NEPA, which has been one of the important statutes for protecting wildlife, in particular in the environment more generally, has been under assault. Having said all that, the statute still exists. It has been amended fairly recently by Congress, but not in a way which really fundamentally undercut what we refer to as the hard look doctrine. And I think there will be opportunities for many of us still to pursue NEPA claims and have to navigate around some of these changes. But we're going to have a rough sledding for at least the foreseeable future on the NEPA front as well.
Yeah, thank you. Emily, do you have anything you'd like to add to that?
I don't. No, I mean, I think that was a really great summary of kind of the state of NEPA. I think we've all been for the past few weeks and months in sort of this like wait and see what is happening with NEPA, which has been such a reliable and important environmental law in all of our practices.
Fundamental.
And it keeps unraveling, yes, in concerning ways. So, yeah, we're going to have to really focus, I think, on at the agency level, the individual agency level, and their promulgation of regulations to try to one, hold them accountable to what the statute actually calls for, and to look for opportunities to challenge new promulgations of very poor NEPA regulations.
Yeah, and along those lines, can I inject one note of optimism since we are sort of going off this way?
Oh, you got
desperately necessary. One thing we can count on with this administration is to overreach. They're not doing things in a particularly scalpel-like way or a particularly, sort of clever way. That just doesn't seem to be the way they're doing things. And we're seeing substantial pushback from the courts. And NEPA itself provides opportunities, as Emily was saying. And so when they come in and just cut out public input entirely, or just ignore entire areas of impact like environmental justice impacts or major wildlife impacts or climate change effects, those are going to be opportunities. And as we're seeing in other areas, I think we can expect pretty strong pushback from the courts and breathe more life into the statute in a way that this administration is trying to undercut. Because the statute on its face is obviously motivated by something which is still in existence, which is the need to consider seriously impacts across the board on wildlife, environment generally. So just to give people a note of, as I say, optimism that there will be substantial pushback, and there are federal judges out there who do care. And, I think that will allow us to at least, hold the ground to a fair degree. It's still very uncertain, but I think there's some basis for optimism there.
Yeah, and I mean, and piggybacking off of that, I think we saw through the first Trump administration, they were not very adept at accomplishing their regulatory rollbacks because the way they went about it was clearly unlawful and very vulnerable to successful legal challenge. And I think history is very likely to repeat itself there, especially when, we see executive orders coming out saying explicitly directing agencies to bypass public process requirements because President Trump says so, essentially. And oh gosh, I had one more point and now it's totally flown out of my head. Hold on one second.
The next question I have is for you, so maybe that'll trigger.
Okay, yes, go for it.
Well, to your point you made a minute ago about really needing to focus at the agency level, can you talk a little bit about what the EPA's approach has been to factory farm water pollution so far, and how you see that changing at all?
Yes, and I actually did just remember my last point, which is that, the executive branch's efforts and DOJ's efforts to gut federal agencies of staff and resources, I think will have a backfiring effect on their ability to really push through their agenda, their anti-regulatory agenda, which is another silver lining to look to. But yes, to your question, when it comes to factory farm water pollution, I really like something that Dana said earlier about how animal advocates really need to see climate action as an important part of their strategic advocacy toolkit. And I think the same is true for the Clean Water Act and clean water advocacy, especially as it applies to farmed animals. The industrial model of livestock production is pretty horrific, both from an animal welfare perspective, of course, because you have thousands or even millions of animals being confined in tight spaces in these factory conditions, but also from an environmental perspective. These operations generate massive quantities of waste, and they have become a huge water pollution problem. And they have been that way for decades, so much so that when Congress was writing the Clean Water Act, they explicitly called out these industrial factory farming operations, also known as concentrated animal feeding operations, in the text of the statute as an industry kind of class that needs to be regulated under the Clean Water Act and through the Clean Water Act's permitting scheme. That's the only industrial category that Congress named by name as something that needed to be regulated because of its wide-ranging water quality impacts. However, the way that EPA and states have implemented that mandate for the past 50 years has been very poor. And they've taken a very kind of light touch approach to the factory farming industry, really treating it as agriculture once was, rather than industrial pollution facilities, which is really what they are. So based on EPA's own estimate, the vast majority of factory farms discharge harmful pollution to waterways, which would mean that they have to be regulated under the Clean Water Act through permits. 75% is EPA's estimate. And as far as EPA knows, although it doesn't have a full inventory, there are over 20,000 large concentrated animal feeding operations across the country. That being said, less than 30% of these factory farms are currently regulated under the Clean Water Act. So there is a huge disparity in who is required to be regulated by law for their water pollution and who is actually being regulated. If you do the numbers out, it comes out close to 10,000 factory farms that are illegally polluting waterways without the necessary federal permitting. EPA has known about this for a very long time, and they have tried in the past to kind of improve their clean water regulation of this industry. They had been met with some roadblocks from courts, and they've sort of thrown up their hands and said this is kind of a too difficult problem that we are not sure how to really address. And on top of this kind of overwhelming lack of clean water permitting that this industry enjoys, the small minority of factory farms that are actually subject to clean water regulation through permits, that regulation and those pollution control standards are very lax. And the way that they treat this industry, again, is really as this is agriculture. The waste products that they produce are beneficial agricultural products that fertilize our land, and we really don't want to do too much to change that, even though that is very far from the truth. I mean, they treat CAFO waste as if it is just manure, essentially, with nutrients that can be used to optimize crop growth, but there are high concentrations of pathogens, of E. coli, of pesticides, of heavy metals, of antibiotics and artificial growth hormones in this waste that is being just not treated, dumped onto fields, kept in large open air waste impoundment structures called lagoons, which are designed to leak into groundwater. And the regulations that are in place at the federal level and in the state level are really inequipped to deal with this problem.
To that end, one of the questions that's come in from the audience said that there's a recent report that 350 wells were contaminated near a Purdue plant in Maryland. What are some of the sort of options that just regular harmed citizens might have to challenge things like that?
That's a great question. I think citizens can bring their own Clean Water Act, their own Resource Conservation and Recovery Act, RCRA claims, which can get at some of this groundwater pollution and drinking water pollution that is really contaminating communities. So there are federal statutes that citizens can bring claims under. States have made it pretty difficult to bring your run-of-the-mill nuisance claim against these operations through what are called right to farm laws, which really kind of give a safe harbor to factory farms as being immune from nuisance suits, or making it very hard to bring those suits at the very least. But there are other ways beyond litigation that communities can work and band together. For instance, we've had success at filing Safe Drinking Water Act petitions to EPA, really asking for emergency action, because states have been failing in their duty to make sure that drinking water sources, groundwater, is being protected, which factory farms are really contaminating. And we filed these petitions with kind of community support and grassroots organizing to really advance the legal tactic of the petition itself, in Oregon, in Wisconsin, in Minnesota, in I'm blanking on there's five places where these petitions are currently pending, and have actually been getting, or at least had been under the Biden administration, and some traction on the federal level of really stepping into these communities and providing some relief and pushing up state agencies to do their jobs when it comes to protecting drinking water and groundwater from these operations.
Okay, thank you. Dana, what are some other areas of policy change from the new administration that you're watching for direct impacts on animals?
Yeah, I mean, we're definitely hearing this here on this panel in spades, and we've heard it on other panels over the course of the symposium. There's just been so much executive action so quickly. It's very hard to follow. It's unprecedented. But there's a lot of we can't cover all the areas in this short time here today. But just to throw out some other issues that we haven't talked about yet on this panel. There's been further deregulation of slaughter lines under this administration. This was discussed yesterday. That's dangerous for animals, that's dangerous for workers, that's dangerous for the public health. So that had been an ongoing process under prior administrations, but we're seeing that continue now, and that's definitely an area of concern to watch. We're also heard yesterday how we're seeing cuts to our already inadequate efforts to monitor and respond to highly pathogenic avian influenza. So some of these employee cuts, have been to USDA staff that were, working on this issue. And, even before those cuts, I think, we're already hearing under the prior administration just how inadequate our response to the bird flu outbreak has been. So that's very concerning. Also, there are complicated things going on in the laboratory animal space, and this is, outside of my area, but I think really interesting to watch. On the positive side, last month, the Food and Drug Administration announced plans to replace animal testing in the development of monoclonal antibodies and other drugs. And that's sort of part of a progression that has been going on from the EPA and the FDA to move away from animal methods to non-animal methods that are now available and effective. So that was a positive development last month. We're also seeing the cuts to federal research funding have led to great uncertainty for the impacts of animals that are currently in labs. And there was some great reporting from the New York Times earlier this week about this issue, sort of talking about how the disruption of federal research funds, what does that mean for the animals that are in the labs right now, that they may have already been subjected to, experiments that are being dropped in the middle. They may have been exposed to pathogens. And what happens? The New York Times was saying some animal advocates see this disruption to funding of animal research as sort of a positive development. Others are really concerned about the impacts on the current animals and what this means for the lives they've already led in labs, and whether there's any utility to the time that they've spent there, and then what happens now. And the New York Times just had some really this is a difficult area to know about. We know there's a lot of secrecy around animals in labs, but the New York Times had some really interesting examples to give us a flavor of the kinds of things that are going on. The National Institute for Occupational Safety and Health had a bunch of employees terminated recently, and there were 900 lab animals there at the time. The employees in the Institute scrambled around. Eventually, most of the lab animals were relocated to other labs, but 300 of the 900 were killed just as a result of this cut in funding. At one of the Institute's facilities, the animal care staff were laid off, and they actually refused to leave because the animals needed to be cared for, which is just, sort of an example of activism. And what do we do in the face of these, massive changes that are being made without sort of a plan for what happens? There was an example from Harvard that there were rhesus macaques, monkeys, that were at Harvard being used for development of a tuberculosis vaccine. And the federal funding was lost. The researchers were, according to the New York Times, considering killing the animals because they just were not going to be able to even afford to care for them. And then a private funder stepped up to pay for the care of the animals. But, we can't count on that in every situation. And, as I mentioned, there's already a lot of secrecy around animal testing. Now there's a lot of secrecy and fear on the part of lab employees and researchers about what to do about the animals. So, if you imagine their situation, and this was highlighted in the New York Times reporting, they're scared of reactions and retaliation from their employees and how they respond to this, from the administration, and from animal advocates. So there's, I think that's really an area to watch as well.
Okay, thank you. Eric, there was a recent report that documented the alarming collapse of bird populations across the United States. What's the status of the Migratory Bird Treaty Act and its ability to protect birds from industrial activities?
Yeah, so as people may have seen, Cornell ornithology folks just recently came out that most recent study showing that 75% of the bird populations in North America are undergoing substantial declines, and that follows on the heels of a prior study which showed that over the course of about 50 years or so, we lost about 3 billion birds in North America. And that's even putting aside the climate change effects that we see coming, that Dana was talking about, just from habitat loss and destruction, and a lot of industrial activities. And a lot of these industrial activities kill birds in ways that are actually pretty easily preventable. If you've driven along the highway and you've seen on some transmission lines, like big sort of rectangular or triangular objects put on the transmission lines, those are bird diverters. Those are put up so that birds come and they see the transition, see those things, and they can avoid hitting the transmission line. Many millions of birds are killed by transmission lines all across the country. Other readily available ways of avoiding bird deaths. And the issue about whether or not those kinds of impacts are covered by the Migratory Bird Treaty Act has now ping-ponged back and forth across several administrations. 4 years ago, after many years in which the government had taken the position that what's referred to as incidental take, which is basically an industrial activity that predictably kills birds in large numbers, even if that's not the purpose of the activity, that was at least covered by the Migratory Bird Treaty Act, and something had to be done by the industry having that sort of impact. And the first Trump administration came along and issued an opinion called the Giorgiani opinion, a solicitor's opinion in the Interior Department, saying, well, we've decided that after all these years, and the MBTA, as people may know, this is a statute that has not been around only since the 1970s. This was one of the very first wildlife protection statutes passed in the early 1900s. And came along and said, well, for the first time in the history of this century-old law, we've decided that none of those industrial activities are covered by the Migratory Bird Treaty Act. So a number of people went to court and sued over that, including 8 states and NGOs, and got a ruling from the judge in the Southern District of New York saying that, no, you're absolutely wrong. Actually started off with a line from To Kill a Mockingbird, which was playing on Broadway at that time, and said it's not only a sin to kill a mockingbird, it's actually a crime. And issued this wonderful ruling saying that no, these activities are covered and it was illegal to simply declare they're not. And the Biden administration came in and changed its approach in light of that opinion and started down the road of issuing new protective regulations, which sadly they never finished. That's another story we could get back to in a moment. That would have changed things substantially. But not surprisingly, Trump #2 comes in and says quite directly, we're going to go back and tell all the Fish and Wildlife Service employees, the enforcement officials, that they're going to follow that opinion that was basically declared illegal by a judge in the Southern District of New York. And if you want to look at what they've done, it is literally that explicit. They don't even purport to come out with a new rationale. They just say, hey, we've just decided you're going to follow that opinion that was issued before. So that's where things have gone back to. We're back to a new declaration by this administration that none of these industrial activities impacts on migratory birds are affected. And as you know, your question suggests, it comes at the worst possible time in terms of broad impacts on migratory birds. So on this one, stay tuned. I think it's fair to predict that there will be a response to this. I'm not prepared to say right now exactly what that response is going to be. But it's yet another example of where they've come in, not only just sort of across the board with these radical changes in approach, but in a way that just seems you're leaving scratching your head as to even what their thinking is in terms of not coming up with a rationale or even pretending to have like an approach that would seem to be legally sustainable based upon what the courts have said before. But they may be banking on ultimately getting up to a higher level of review. And to pick up on what Emily was saying before, I think a lot of what this administration is doing is hoping that some of these very radical positions will ultimately make their way up to a friendly Supreme Court. And that's something that all of us doing this work also have to take into consideration. How do we push the ball forward? How do we push back, knowing that at the end of all this, you may have a court which is clearly not sympathetic to wildlife interests or environmental interests.
Wow. Well, I mean, relatedly, the government also has proposed to rescind the definition of harm in the Endangered Species Act regulations. Can you explain a little bit about what that means and what some of the consequences might be?
Yeah, so this is another interpretation that has been actually sitting on the books for decades. Unless you think it was a regulation that was some kind of radical left-wing idea. It was actually adopted during the Reagan administration, defining harm in a way that perhaps not surprisingly would encompass habitat destruction or modification, but in a way that's actually directly related to animal impact. So defining harm in a way that encompasses habitat destruction or modification that actually kills or injures wildlife. So not something which is abstract. That is what the regulation said. You had to prove, in order for there to be a take under this part of the Endangered Species Act, that there would be actual death or injury resulting from habitat loss or destruction. And that's a rather narrow definition, but even that was too broad for this administration. So very recently, as people may have seen, this has gotten quite a bit of coverage in the media. The Trump administration came along and said, we're going to rescind that regulation in its entirety. We're not even going to replace it with anything. We're just going to eliminate the regulation which defines habitat loss and modification as a prohibited take under the Endangered Species Act, where it actually kills or injures wildlife. And actually, to go back to something that Emily mentioned before, which is the Loper-Bright decision, as people may know, that's the one that said we're no longer going to defer to agencies. We're now, just basically come up with our own best interpretation. One of the rationales that the administration gave was that, well, that regulation was issued under a Chevron framework, which is the prior deference framework. We don't have to operate under that anymore. And even though there had been a Supreme Court decision called Sweet Home, which had upheld the regulation, they had done so under the Chevron framework. We're not under that anymore. So we could get rid of all that. We can declare that Justice Scalia's opinion in that case, which was the dissenting opinion, is the best interpretation of the statute. And we're going to rely upon the dissenting opinion to say that we're going to get rid of this harm definition so that harm would no longer encompass any kind of habitat loss or degradation. So obviously there's comment period right now. People want to weigh in. You can go to the center's website or others to get input on how to comment on this. There's an open comment period right now. We don't have any expectation this is going to change the mind of this administration, but the more people comment, the better. And of course, there will be follow-up lawsuits over all of this. One sort of, again, optimistic note on this, since it's good to always keep trying to inject these. Whatever they do on this front, they can't change the statute. The statute makes it unlawful to take wildlife, including harming wildlife. And so harm, the natural reading of harm, as the Supreme Court had said in the Sweet Home decision, encompasses destroying a wildlife's place to live in a way that results in foreseeable, killing or injuring of the wildlife by interfering with breeding, sheltering, other forms of basic life functions. So no matter what they do, the statute is there, and there has been very little effort across the board to just dismantle the Endangered Species Act itself. So whatever they do on this regulatory front, there will still be opportunities to try to press for enforcing the statute. Unlike some of the other statutes we're talking about, the Endangered Species Act has a very strong citizen suit provision. So there are opportunities to sue regardless of what the administration decides it's going to do on its side of things.
I do think that's a great point that, legislation matters, laws matter, that, public opinion can ebb and flow, but when you chisel something into the law, it has a more of a permanence to it. I mean, when we were gearing up for the 50th anniversary of the Endangered Species Act, which in 2023, I was looking up, and it's astounding to me. I think it passed unanimously in the Senate, had only like 17 votes against it in the House, and then was signed into law by President Richard Milhouse Nixon. And that it is probably the most litigated animal protection statute, and it's had massive impacts on commerce and business. Yet it's, as you say, it's still there. There's no chance of them actually going in and repealing it. So it's just another reminder how important it is to get these laws passed, because once you do, it sort of, again, just chisels public opinion into a bit more permanence. Emily, there's been a groundswell of nonprofit advocacy targeting EPA's inaction on factory farm water pollution in recent years. Can you walk us through the gains that have been won and what you see on the horizon?
Sure, yeah. And I think I'm happy to answer this one because I feel like my previous answers have been pretty doomy, gloomy, but we actually have been gaining ground when it comes to winning slow but sure progress on how this industry is regulated from a water pollution standpoint. And it's been a really kind of long game advocacy strategy that Food and Water Watch has led on and put in place back in 2017. So I think it's important to note that kind of this whole cycle of advocacy on this issue began right at the beginning of the Trump administration. Not because we thought that administration would do anything helpful for us, but because kind of running out the clock on Trump was a strategic part of the plan. So back in 2017, we filed a petition for rulemaking with the EPA to strengthen its regulatory program, Clean Water Act program for CAFOs. There's a provision of the Administrative Procedure Act, which essentially allows any citizen, any nonprofit group, the public to petition a federal agency to strengthen, update, change, eliminate regulations. And while the agency doesn't have to say yes, they have to answer the petition, and they have to support their answer with a reasonable explanation for their decision. So it's a sort of a legal hook to get the agency to pay attention and force a conversation and hopefully a good outcome. And the petition that we filed was a really in-depth look at the deficiencies of this clean water program and had a number of specific recommendations and proposals for exactly how to overhaul and reform the regulatory program to accomplish kind of two main goals. One, to ensure that every discharging factory farm in the country is actually subject to Clean Water Act permits as the law requires. And two, that those permits are actually protective of our nation's waters. Because as I discussed earlier, neither of those things are the case. And while we were kind of waiting for a response, we didn't get a response until the Biden administration. And in fact, we had to sue to even get a response based on the government's unreasonable delay in responding to the petition. But that's where it comes in of it was helpful to kind of ride out the Trump administration and rack up some years on this petition that was accruing to justify this unreasonable delay claim. But in the meantime, not only has this petition really been a a regulatory roadmap for reform, it's also for us been a strategic litigation roadmap. So as we were waiting for an agency response, we were sort of ticking off like a certain specific recommendations and using them to bring lawsuits against EPA to force action on the issue. So for instance, one of the things that this petition called for was EPA to finally begin doing what the Clean Water Act actually requires, which is to implement representative monitoring in CAFO permits. So basically the way Clean Water Act permitting works is a polluter cannot discharge unless that discharge is authorized by a permit. The permit imposes or is supposed to impose strict pollution control standards to limit and eventually eliminate the pollution. And kind of to complement that, the permit is also supposed to require monitoring of the discharging activity to ensure compliance with the terms of the permit. And that's something that is standard throughout all industries and all Clean Water Act permitting, except when it comes to this industry. EPA has not historically required CAFOs to do any sort of monitoring to make sure they're complying with their permits, and neither have states. So we brought the lawsuit directly in the Ninth Circuit Court of Appeals to challenge this flagrant violation of federal law, and we won that issue. And we've then now been able, and that was back in 2021, and we've been able to take that win at this Court of Appeals level and now use it in states where states have delegated Clean Water Act authority to, once their general permits, so general permits are permits that are for the entire industry. And rather than having an individual CAFO operation with an individual permit, they apply for coverage under this general blanket permit for all CAFOs in the state. And so we've been winning on this monitoring issue in states where we've been bringing this action in. So for instance, in Washington, we have ongoing actions in Colorado and Montana to force monitoring, which not only, upholds the law and subjects CAFOs to more rigorous requirements, it also gives citizens and advocates more information, really, to understand the depth and severity of the pollution problem caused by the industry. Another thing that the petition called for was updating the effluent limitation guidelines. So these are the standards that govern the pollution controls going into CAFO permits, and they are woefully out of date. They haven't been updated since 2008, even though EPA has a continuing annual obligation to look at these guidelines and update them as necessary. And it's been very clear, especially with the evidence presented in the petition, that these guidelines as written are not effective and they need updating. We brought a lawsuit in 2021 to challenge the deficient review that EPA has been doing for years and years of these guidelines, which basically forced EPA to back down and say, you're right, we've been doing a terrible job at this review. We don't know what's going on with this industry, and we haven't really looked at it for 15 years. So what we're going to do is we're going to start a detailed study of the factory farm industry, the nature and quality of the water pollution coming from these operations, and kind of what technologies are available to effectively control it, to see what updates we need to make. In 2022, we filed a lawsuit because EPA had still not answered our petition after almost 6 years. And EPA immediately came to the negotiating table and agreed to answer the petition within a matter of months. After that lawsuit was filed, Earth Justice led a similar CAFO petition that was re-upping one of the major asks of our petition, which was to establish kind of a presumption that CAFOs that had certain characteristics would discharge and therefore needed permits, which got a lot of support kind of from a coalition of advocacy and environmental justice groups. In 2023, EPA came down with its answer to our petition, in which they denied it in full, and they kind of cited as their main excuse we really don't have enough information to decide whether or not these regulations need to be updated. So we need to keep going with this detailed study that you forced us to do. And we're also gonna, pull together a stakeholder group, federal advisory subcommittee group focused on this issue to give us recommendations. We challenged that denial, which is something you can do, although it's a very difficult standard to actually meet. Trying to force an agency to issue or change regulations when it's decided that it's not going to do that. And though we were not successful in that challenge, the Ninth Circuit, which is where we brought it, specifically relied on EPA's promises and commitments to study this industry thoroughly and to proceed with this advisory committee group. It took it at its word that this is a serious problem that needs to be addressed, and these things would help EPA address it. So it really kind of set the stage for, should the Trump administration eliminate this advisory group or stop this detailed study, I think we might have pretty compelling grounds to go back to court to say EPA said this was absolutely critical to fix this industry and it knows there's a problem. So if it's going to stop doing that now and essentially have lied to the court about what it needed to do, we need judicial kind of action and intervention into this problem. So this is an ongoing kind of snowball effect of advocacy work and slow but sure change in this arena.
Well, yeah, thanks so much for that perspective. We only have a few minutes left, so I wonder if we could just do a quick lightning round and have you each spend just 1 minute, if possible, on what each of your biggest lessons or takeaways from your experiences working on these issues. We'll start with you, Dana, in the hot seat.
Oh no. I guess just I love being part of this movement and being a part of experiences like this panel. We all learn from each other. We all stand on each other's shoulders. Chris, I'd never heard of animal law until I was well out of law school. And Chris, you welcomed me into an American Bar Association Animal Law Committee meeting. That's where I met you and I started learning about the field. So just thank you to ALDF for giving us this opportunity to come together and learn from each other. It means a lot.
Thank you. Eric, what do you think?
Well, I agree with all that. But I also pick up on something that Emily, I think, finished with, which is you have to take the long view of these things. A lot of these battles are very long-term strategic battles, and you frequently don't know how they're going to turn out for a long time. And that's why you can't give up hope. We're in a bleak time right now. There's no question about it. But bleak times go past, and I have actually a longer view than probably anybody else, certainly on this panel, and most of the people listening, I would imagine. And you get past the bleak times, but if you stick together and you have a long-term strategy, then things can frequently turn out better than you think they're going to. So while we were talking about things we would prefer not to be talking about, there's no reason to give up hope, and especially for people, younger folks, we need to pass the baton, some of us. So we're really happy that you're interested, enthusiastic, and going to be great advocates, and look forward to, all the great work that a lot of the folks listening in on this and ALDF is helping to support and interact with, all the work that you're going to do.
Thanks, Eric. Yeah, I think many of us were very pleasantly surprised by the Supreme Court's Prop 12 decision. Is a great example of that. Emily, what are some of your biggest lessons or takeaways?
Yeah, I think this space is really unique in that kind of to push forward a shared vision for animals and animal agriculture. A lot of kind of unique interests come together to do that. Environmental focus groups, animal welfare focus groups, sustainable farming groups, kind of all working hand in hand towards a shared goal, which I really appreciate. And I think it's really not just any one particular thing. It's not just litigation or policy advocacy or narrative shifting work. It's all of this work together, and all sorts of different advocates who have all sorts of different skills and focuses that is really pushing this work forward.
Great. Well, that closes our 2025 Animal Law Symposium on shifting legal landscapes in a new administration. Thank you to our panelists, Dana, Eric, and Emily, and to all of you attending. We're so appreciative to you for joining us and hearing these thoughtful perspectives from our panels of deeply experienced experts. Over the past 2 days, we've learned about significant changes at the Food and Drug Administration, recent evolution in legal standing, issues related to the First Amendment, and finally, as you just heard, future challenges to animals and the environment. I'm incredibly grateful to Christina Stella and ALDF's litigation program and Caitlin Hawks for putting so much time and thought into planning and curating these wonderful conversations. I also really want to thank Anne-Marie Vestano, Megan Hume, Jody Papaleo, and Liberty Mulcani and ALDF's events team for all of their extensive work organizing the symposium and ensuring that it ran so smoothly. And thanks most of all to our excellent panelists for taking time out of their busy lives and schedules to share their knowledge and expertise with us all.